Civil Rights Actions, Title 42 U.S.C. Section 1983. These statutes create a cause of action against any individual or person who, acting under color of state law, abridges rights created by the Constitution and the laws of the United States. It was originally passed by Congress as a part of the Civil Rights Act of 1871. It does not create federal court jurisdiction but a cause of action, a legal entitlement to relief against those who, acting pursuant to state government authority and the common practices or policy of various state agencies, violate federal law. You must prove that it was the custom and policy of the state government authority or state agencies to violate your rights. Other applicable statutes include Title 42 U.S.C. Section 1985. Conspiracy to interfere with civil rights, Title 42 U.S.C. Section 1986, Action for neglect to prevent conspiracy, and the Racketeer Influenced and Corruption Organization Act. RICO, Statutes. Point 87-252. Chapter 16 Civil Rights Actions, a Title 42 U.S.C. Section 1983. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any subjects or causes to be subjected, any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. Title 42 U.S.C. Section 1983-27. When federal officials violate a person's civil rights, they are said to be acting under color of federal law. They can be sued pursuant to the Bivens Doctrine. 28. The jurisdiction to hear this action exists under 28 U.S.C. Section 1331 and 28 U.S.C. Section 1343a(3). These sections grant jurisdiction to redress violations of federal laws that provide for the equal rights of citizens. Immunity. To overcome the defendant's claim of qualified immunity and the immunity defenses raised by government entities in a motion to dismiss, the plaintiff must sufficiently plead 1. That under the circumstances the reasonable person would have known that the conduct violated well-established law. 2. That the conduct was in accordance with the entity's policy and custom. 3. That in the case of a single occurrence, the conduct was initiated by or acquiesced to by a final policy maker with respect to that particular conduct. 4. That the defendant's conduct violates rights protected by the Constitution or laws of the United States, and 5. That the violation of the Constitution or laws of the United States was the proximate cause of the plaintiff's damages. This is the point in the proceedings where evidence can be entered into the court record regarding the oaths of allegiance and oaths of office and the lack thereof of the individuals claiming government immunity from prosecution. Immunity did not protect a state official who was acting under an unconstitutional state law or who was exceeding his properly granted authority. Osborne v. Bank of the U.S. 9-738-1824. Often federal officials, including members of the U.S. Congress and the justices of the U.S. Supreme Court, will argue their defense solely on the position that they were immune from the consequences of their acts, including the consequences of their refusal to perform a duty. These arguments of government immunity have in effect placed federal officials above and outside the law. Thus they are protected from criminal prosecution and the government corruption continues unabated. These are the mentalities that permit inflicting massive harm upon the public and irresponsibility on behalf of the government to be accountable to the law. The legal fraternity's position was, and is still today, that federal officials, judges, and members of Congress could engage in outright criminal acts of cover-up, misprision of felonies, obstruction of justice, and be immune from the consequences. Even the U.S. Supreme Court justices, when personally sued for violation of rights under color of federal law, argued the 9 justices of the Supreme Court are entitled to absolute judicial immunity from plaintiffs' claims. A judge will not be deprived of immunity because the action he took was done maliciously or was in excess of his authority. Supreme Court justices' argument against the lawsuit of Rodney Stick 29. This contradicted an earlier decision by the same U.S. Supreme Court justices who held there is little support in the common law for a rule of judicial immunity that prevents injunctive relief against a judge. There is even less support for a conclusion that Congress intended to limit the injunctive relief under Section 1983 in a way that would prevent federal injunctive relief against a state judge. Pulliam vs. Allen, 466 U.S. 522, 1984, 30. To overcome the defendant's claim in the motion for summary judgment, the plaintiff must also argue sufficiently in the pleadings, depositions, answers to interrogatories, admissions, and affidavits that there are material facts to prove the case with the preponderance of the evidence. Although these statutes were originally created for U.S. citizens, in particular the newly freed black slaves, they are applicable to sovereign state citizens as a remedy for continued violations of unalienable and constitutional rights. Under the color of state law, there is a debate as to whether or not a Title 42 Section 1983 subjects the sovereign state a citizen to federal jurisdiction or not, and whether or not it compromises sovereignty or not. Rick Schramm and Richard MacDonald are still hotly debating the issue. I assert if the action is brought on the common law side of the federal court, i.e., District Court of the United States, then jurisdiction is not waived. Other components of a Title 42 action include 31. Civil rights litigation and complaint. Motion for summary judgment. Motion to strike. Brief in support of plaintiff's motion to strike. Summary of points raised and authorities relied upon. 253. Journey Liberty, Global Sovereign's Handbook. In a Title 42 Section 1983 action, all previous related actions are 1. Immediately estoppeled. 2. To defend against a Title 42 is expensive whether you win or not. 3. You might actually win a case or settlement. No insurance company will insure against constitutional violations. If a Title 42 action gets beyond Rule 12b and the federal judge doesn't toss it out as frivolous, then the bonding company for the defendants must post a bond for 10% of the total suit. Then you can proceed to take depositions and interrogatories. Have fun with it.